The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. We have 3 cases that will be submitted this morning. Those cases are as follows. Nolan Deeds versus the City of Marion, St. Luke's Workwell Solutions, and St. Luke's Healthcare. Second case is Paul Barrows and others versus the City of Davenport Zoning Board of Adjustment and others. And the final case is Nolan Deeds versus City of Cedar Rapids and others. That last case is now submitted to the court without an oral argument, and will proceed to hear the arguments in Deeds versus City of Marion. Mr. Borland.
Thank you, Mr. Chief Justice. Good morning to all, and may it please the court. The defendants in this case seek to escape liability for disability discrimination and for aiding and abetting disability discrimination through the use of a contract that allowed a third party to conduct a pre-employment medical screening of a firefighter applicant. There are 2 specific holdings that we ask this court to reach in deciding this case. First is that when an employer denies employment to a qualified applicant with a disability based on the results of a medical examination, and the examination result was based solely upon the applicant's disability, then a reasonable jury can find that the employer made that employment decision because of the applicant's disability, consistent with the Borland case. Second, we ask the court to hold that when a medical provider serves as a gatekeeper to employment rather than merely as an advisor in the employment decision-making process, that medical provider can be, that a reasonable jury could find the medical provider liable for aiding and abetting disability discrimination. The overarching question in this appeal is whether it will condone whether the court will condone a contractual arrangement allowing both the employer and the contracted medical provider to escape any liability at all for the disqualification of a qualified applicant for employment solely on the basis of disability. The primary flaw in the district court's summary judgment order in the Marion case is that it ignored the holding in Borland that an employer that takes action against an employee based on something that is causally connected to the employee's disability has acted because of the employee's disability. That is not new law. That case is 24 years old. The district court...
Counsel, in Bowman, though, didn't the employer know about the disability? Is that right?
Well, Your Honor, I would agree. I don't think that that distinguishes the case here or limits the holding in Bowman from applying here.
Do I understand the record correctly that in this case the fire chief did not know the reason that the applicant flunked the physical?
I want to be very specific in that answer, Your Honor, because it is a key issue in this case. The fire chief testified, he admitted that he knew that a medical issue resulted in the disqualification. The city puts all of its eggs in the basket that because the fire chief did not know that that medical condition was multiple sclerosis, then he could not have discriminated based on that diagnosis.
Well, the problem I have with your position is that it seems as though you're asking us to find that employer can discriminate based on a disability the employer doesn't know the applicant has.
If this were a case where the employer had no knowledge at all that a medical issue was motivating their action, I would agree with you. But under the facts of this case, the Chief Jackson, testified that he did know it was a medical issue. It was.
Well, let's play around with the facts. Okay, I mean, let's say in this case, and this is, I assume, what you think should have happened. Let's say in this case, the City of Marion should have asked your client after the medical, it came back that there was a medical issue. Would you give me a release so I can find out about the medical issue? Then, let's say your client says, I decline to do that. Would you agree that the employer is not liable in that circumstance?
Right, so the difficulty is that in this case, there was a medical release. There was a medical release in the file specifically allowing Unity Point to provide information to the city of Marion. The release was very specific there. If the facts were different, if there was not a medical release in this case and Mr. Deeds had refused to produce it, then I think you do have a different case and a different result. If Mr. Deeds had refused to provide information about his disability or had somehow refused to engage in some discussion about it, it's different. But he did give permission for Unity Point to provide information about the disability to the city of Marion. And
Am I correct that the city in this case did in fact ask for some type of follow-up examination or follow-up evaluation, I guess I would call it, and then he refused to do that?
well,
So
Justice
that we
Zager, I
could
think
have
that's...
gotten, some additional information or known these facts?
So the employer did not do that before denying employment to Mr. Deeds. The city in November of 2013 denied employment to Mr. Deeds based on the medical disqualification. At that point,
When they offer to do this further evaluation, isn't that somewhat of reopening of the door or re-examination, and we could maybe reconsider our decision not to hire you if we have additional information and facts?
I think perhaps that's an argument that the defendant could make in pursuing a failure to mitigate defense at trial. That would be a factual dispute for a jury to resolve. So I think something very important to keep in mind is this case was dismissed on summary judgment. There are disputed facts as to the qualification of Mr. Deeds to perform the essential functions of the firefighter job. There are 3 neurologists, 3 board-certified neurologists who say Mr. Deeds absolutely could perform the essential functions of
But
Mr.
the fire chief didn't know that, and ordinarily, we don't hold an employer liable for failure to make a reasonable accommodation when the employee or applicant doesn't ask for an accommodation. Why didn't Mr. Deeds push back when he's told, we have to rescind your offer because you flunked a physical?
Again, I think that's going to be a defense argument to be made at trial as it relates to mitigation of damages.
Was
So-
it undisputed that he didn't tell the fire chief, hey, I've got a doctor that says I can do this job?
It is undisputed that Mr. Deeds fully complied with the pre-employment medical examination. There is no evidence in this case that Mr. Deeds specifically told Chief Jackson, in the Marion case, that another doctor disagreed. He took the rejection and he tried to move on. I think absolutely a jury could fault him for that.
What
But-
authority is there for requiring the city to do further inquiry?
So the requirement to do further inquiry it's a little complicated because in this case, the city understood that it was a medical disqualification that it was basing its decision upon. So its duty at that point isn't necessarily to ask for another doctor's opinion. It's to find out what the basis for the disqualification was. So
What legal authority says that they have to ask for further information? I mean, it seems like the city just subcontracts these all out. They just didn't do it to your guy. They do it to anybody who employs. So, and they rely on those people that they're fit. So, I mean, where under the law are they required to do inquiry when your guy doesn't start raising a stink, for lack of a better word?
So the legal authority preventing the employer from making that discriminatory action, from taking discriminatory action, is just the plain language of the ICRA. They discriminated against Nolan because of his disability. The only basis for denying him employment was his multiple sclerosis.
But the only information they had was he couldn't do the duties of the job.
That's not correct, Your Honor. The information they had is that a medical issue was preventing him from performing the essential functions of the job, according to Dr. McKinstry. There was a place on the MFP RSI form that asked for Dr. McKinstry to explain why. And Chief Jackson, even noting and admitting that the form he received didn't include that information requested by MFP RSI, simply took it and acted on it. And when an employer acts blindly, in blind reliance on a contracted medical examination, then they can face liability. The cases that we're looking at for that One would be Adams v. Rice. It's a DC Circuit case from 2008 that's cited in our briefing. In Adams v. Rice, it says that in pure discrimination cases, an employer's knowledge of the precise limitation at issue is irrelevant, so long as the employee can show that her impairment ultimately clears the statutory hurdle for a disability. The employer will be liable if it takes adverse action against her based on that impairment. So I think if you look at Justice Laverado's dissent in the Sahai case, you get a warning of exactly what was going to happen if this type of structure was allowed. And Justice Laverado warned that creating an immunity for medical providers under the guise of professional judgment could result in this. An employer who blindly relies on that is subject to liability. They are taking the risk when they're told nothing but there is a medical issue, you shouldn't hire this person. The employer takes the risk that they are making that decision based on a disability.
What does the record show Mr. Deeds did when he learned he was found medically unqualified? Did he go back to Dr. McKinstry and say, hey, other neurologists say I can do this?
No, Your Honor. That information was made available to Dr. McKinstry even before she disqualified him. If you accept the defendant's version of the facts, Dr. McKinstry reviewed the medical record, which included releases from board-certified neurologists saying Nolan Deeds can perform the essential functions of this job. So I feel like a jury, because again, we're at summary judgment, a jury could infer that Nolan didn't have any duty to re-educate the doctor who had just disqualified him. Another important fact in that regard is that he had been to St. Luke's Workwell for a Cedar Rapids exam right before that, had fully complied with the request that he provide detailed medical records and information about his condition. Again, those records indicating from 3 neurologists that he can perform the job, and he was denied in that instance. So,
Does the record, I've got an earlier question, when he had been a volunteer fireman for the city of Coralville, but when his MS came up, they told him he couldn't do that anymore. Did he challenge that?
Your Honor, I think our position is that it would not be relevant. No, he did not. The disqualification from Coralville, I think, makes more sense than Marion and Cedar Rapids because it occurred immediately upon his diagnosis. When Nolan is interviewing and going through the process with Cedar Rapids and Marion, he's being treated. And he has neurologists signing off saying that he can go and safely perform this work. So the medical provider that the city entrusted to make this decision has all that available to her when she decides. The city chose to rely on a blanket exclusion instead of asking for details to make an informed decision. That's where these two concepts of liability for Unity Point and liability for the city merge into one.
Counsel, let me ask you, Dr. McKinstry consulted the National Fire Protection Standards, is that right?
Yes, Your Honor.
In that, are those medical guidelines?
The record in this case would not allow a reasonable jury to infer that those guidelines were based on solid medical evidence. There is, and it would be a disputed question.
All right,
So-
and that's the only thing that the doctor relied upon?
Right. So
She didn't make a medical judgment. She applied the judgment of this association.
I think that would be our stance, Your Honor. I do think that's a disputed fact. The defendants will say that the NFPA, it's a national association, there's a bunch of doctors involved, but they didn't lay any foundation supporting that those guidelines were actually sound medicine in this case. And our neurologists, again, there's 3 neurologists who have opined on Mr. Deeds' ability to do the job, even in light of the NFPA. That's why we keep hammering home this point that this is a fact question. A jury has to decide whether Nolan Deeds is qualified to safely perform those functions. As far as Dr. McKinstry applying professional judgment, we also cited in our briefing to her testimony that she had no training on the NFPA, she had no training on the municipal fire and police retirement systems protocol for conducting these examinations. This is much more similar to the Rohrer case that we cited, where a physician made a disability-based disqualification and then used the NFPA as cover. Now, I will acknowledge that Dr. McKinstry went and looked at the NFPA while Nolan's in her office, according to her. Nolan disputes the facts surrounding that event. Dr. Westphaling, who's a former firefighter and who the city relies on very heavily to support the disqualification, disagrees with Dr. McKinstry about his level of involvement and whether he told Dr. McKinstry that she should use the NFPA or not. There are disputed facts underlying that question of judgment, Your Honor, and that's part of the reason that we think aiding and abetting is an appropriate claim here.
What's Iowa law on the tort of aiding and abetting? Do you have to prove that the principal committed a tort? So hypothetically, if we found the city, because it did not know about the MS, couldn't have discriminated and find no violation by the city, is that fatal to your aiding and abetting claim?
Your Honor, the Court of Appeals held that it was. It looked at cases from California and New York on that as well. We did not challenge that in this case. And the reason that we're not challenging it, first off, is we're very comfortable that the city had sufficient knowledge that its decision was based on disability. So despite the fact they didn't know that the disability was multiple sclerosis, Chief Jackson knew that this was a medical condition, and he chose not to ask the doctor for the basis. He acted, he put himself and he put the city at risk by going forward and making a decision that ended up being based on a legally sufficient disability.
I mean, there were two people who could have, two ways to find out what the basis was. One is the city could have asked the healthcare provider, assuming the healthcare provider was willing to do it under this release that gave it full discretion to disclose what it thought it needed to disclose. Or your client could simply have told the city. What's wrong with putting the obligation on your client to disclose it?
Because it's a fact question, Your Honor. That is not a legal holding. You cannot determine as a matter of law that the city did not violate the ICRA because Mr. Deeds did not disclose additional information beyond what was requested in the pre-employment physical that he fully complied with. A jury could look at this question and could say the city is not liable. I completely agree with that. But that's not a question of law.
But if we say the legal standard is you can't discriminate based on disability if you don't know about the disability, under that law, doesn't it then become your client's obligation to relay the information?
If that were the case here, Your Honor, I think I would agree. If we had an invisible disability with no mention of medical infirmity or disability going to the decision maker, then I would be inclined to agree.
So your view is whenever an employer has notice of a medical issue, they have an affirmative obligation to get more details and find out whether it's a disability or not.
No, Your Honor. Our position, is that when an employer receives information indicating that a medical examination is the reason for the disqualification, and the employer chooses to just act on that, the employer has acted because of disability, so long as the condition is a disability.
Yeah, we can frame the issue how we want, whether you want to say chooses on it or whatever, but your position is if the employer has knowledge that there is a medical reason why the individual is not qualified, they then, your rule of law would be they then have an affirmative obligation to go and gather more information.
Or risk discriminating against somebody based on their disability. Absolutely, Your Honor. And this is not, we need to draw a line between this case and reasonable accommodation cases. So the vast majority of cases cited by the defendants in their briefing are reasonable accommodation cases, where there's absolutely an affirmative duty on the employee to notify the employer of a need for accommodation unless it's obvious to the employer or they have some other reason to believe there's a disability. That same law doesn't apply in a straight disability discrimination case. That rule is satisfied by the employer being told a medical examination has disqualified your candidate. And when the doctor doesn't provide any information about why, even though they've been asked to, if the employer acts on that information, they act at their own peril, and they may expose themselves to a claim for discrimination.
What if an employee simply comes up and applies for a job and says, I'd like to work here, I'm qualified, I think I can do the job. They're interviewed, they're given a tentative job offer, and the employee says, well, I think there's a medical issue why I can't work here, and walks away. What's the employer's obligation in that situation?
To be blunt, Your Honor, I don't think they have an obligation because the employee has just voluntarily resigned, and there's been no adverse employment action taken by the employer.
We can play with the facts, but you understand what the hypothetical. It's the same case as this, except it's the employee saying I'm not medically qualified as opposed to a third-party provider.
Sure.
Is there liability in that case potentially as well?
If the employer had fired the employee because the employee said that they thought they had a medical issue that interfered with their ability to do their job.
Not fired, didn't hire in the first place. The same facts as this case,
Okay.
but instead of the information concerning the medical, instead of an outside healthcare provider says this person is not medically qualified, the employee says, well, on reflection, I'm not medically qualified.
So the reasonable accommodation law that's cited by defendants would say that's enough to trigger the employer's duty to inquire. So yes, if we moved this into an accommodations case, and this, I do not agree that the facts are the same here. The facts here are that the employer sent the employee for a pre-employment medical exam. The employer's agent, Dr. McKinstry, conducted the exam, learned of the disability, learned of the full scope of the history of the disability, and made the decision that she communicated to the employer. The employer testified, Chief Jackson testified, he did not have the authority to overrule her. So that's the decision that stood. This was not the employee saying, I have some medical issue. This was the employee telling the person that he was sent to, Your Honor, may I finish my thought? Thank you. The employee fully disclosing all the information to the medical provider selected by the city, and the city acting on a disqualification without bothering to find out why. Thank you.
Mr. Borland, thank you as well. Ms. Reasner.
Good morning. May it please the court. As you know, I'm Amy Reasner. I'm here to represent the city of Marion, and we're asking that you affirm not only the district court's decision, but the Iowa Court of Appeals decision. Your Honors, as I listened to this argument, I thought about one word, and that's duty. This case isn't a fact question, it's a legal question about duty. And all of our precedent, when we talk about disability discrimination, focuses on a shared duty. And it's a heavy burden on the plaintiff, whether they're an applicant or an employee. They have a responsibility when they have superior knowledge to start a process with the employer to discuss their needs for accommodation. This case was about an unobservable, unknown disability. The record is very clear that when Mr. Deeds applied and was interviewed, there was nothing in his appearance that led the employer to understand that he had a medical condition.
Let me ask this question. So I understand that there was a contractual relationship with the physicians and the employer in this case. But supposing there was not a contractual relationship and the physician was actually employed by the city, within the city's roster. Under the facts of this case, would there be a triable claim of a violation of the Iowa Civil Rights Act based on disability?
I think the answer to that question is yes, because that is an agent of the employer. Now, Mr. Deeds wants to contend that Dr. McKinstry was our agent, but that simply cannot be here under the facts in this record.
Well, but you see where this is leading. It tends to be a form over substance problem to me that I'm struggling with, and I seek your assistance. But the disability law generally stands for the proposition that stereotypes about people that have disability like MS, oh, they're not qualified for the job, don't cut it. That we ordinarily have to have an individualized inquiry into the essential functions of the job, what the disease as to this individual does, and whether there's accommodations. Yet here we've had a blanket stereotypical statement saying MS disqualified, period. The end result in this case is cutting into the core of disability law. Is it not?
I respectfully disagree for two reasons. One, there was an individualized assessment here. The record is clear that Dr. McKinstry spoke with Mr. Deeds, who did not disclose to her that he had multiple sclerosis. She then remembers this issue, speaks to Dr. Westphaling, and how much they spoke, it doesn't matter, they did. She reviewed the NFPA, which I do not concede is a blanket exclusion, it's a guideline. And then she reviewed his medical records. And her testimony was that she made her decision on the basis of Mr. Deeds' time course of illness.
But isn't that the fact question, whether she did an individualized one or not? I mean, they say they didn't because of the other standard that doesn't automatically disqualify you, and there is, when you read this record, you do get the indication that she may have disqualified him automatically, and she put no reason in the form that went back to the city, and the city did nothing to do further inquiry.
That goes to my second point, Your Honor, which is she's not our agent. The city of Marion asked Unity Point, not Dr. McKinstry, but Unity Point, to provide an advisory opinion with respect to a specific job description, specific essential functions of this position, and within the MFPRSI guidelines. The city did not tell her how to render that opinion. The city did not tell Dr. McKinstry what texts to review or to confer with a colleague or not confer with a colleague. And so in the end, she is not our agent. My chief, Chief Jackson, stated that
She's your contractor. What's your difference for the purpose of liability here?
She is our contractor, but the purpose for liability is that we don't control that opinion, one, and two, we had no discussion with her about Mr. Deeds whatsoever, two, and Chief Jackson indicated that the ultimate hiring and firing decision is his. He said if he had received a document from Dr. McKinstry that had said something more, that he would have taken it to Human Resources and considered potential reasonable accommodations. Your Honor, I think we need to move back to the point at which this case was decided, and that is whether this was a decision because of disability, and the decision was the city's. And the city did not decide to revoke this job offer because of a disability.
Well, but it was because of an unqualified statement, it seems to me, that the applicant was medically unqualified for the job. The question is, kind of what state of knowledge is required to show discrimination. It's this magic word because of, or phrase because of, that there's a gazillion cases trying to tell us what that means. On the one hand, perhaps it's your position, it's not implausible to suggest that you have to have subjective knowledge of the specific malady. And here it's clear, I take it, that Chief Jackson, and on rebuttal you can correct me if I'm wrong, but Chief Jackson did not know that there was an MS issue.
Correct.
But he did know that there was a medical disqualification. Because of the medical disqualification, arguably an otherwise qualified person was denied employment. There's cause and fact, it seems. And the question is really, to what degree do you need a subjective component? And if you have a subjective component, what exactly is it? Now, is it your position that they have to specifically know that it's MS?
No, Your Honor. My position is, in these facts, Mr. Deeds, who had, as what's been described in Kratzer versus Rockwell, in this case, the district court judge said he had superior knowledge. In this case, we need to focus on the duty, and who had the duty to say something.
I think we have to focus on the statute. I mean, I'm pushing back a little bit, but the statute says because of. I will tell you, I find that a very unsatisfactory phrase, and 1,000 courts would agree with me. What does because of mean under the statute?
Well, let's use Streeter versus Premier Services in order to help frame this conversation. Judge Strand in the U.S. District Court had basically this same case, and we've cited this to you in our resistance for further review. In that case, you have an employee who actually doesn't show up for work and brings a doctor's note. And the doctor's note says he was seen at the VA clinic. Doesn't say why, doesn't say that he has a disability, doesn't even say that he was incapacitated. It simply says he has a doctor's note that he was seen at the VA clinic. Whose duty is it at that point to have a conversation about what happened? The employer didn't even know that there was a disability claim until it received an agency complaint. That's this case. And so if we use that case where Judge Strand said the employer couldn't have discriminated because it didn't know of a disability, and Mr. Streeter failed to apprise the employer of the issue. This does relate back to the interactive process, Your Honor. All of this is tied together. In our disability discrimination law, we say there's a shared duty, but the greater duty is on the employee or the applicant because it is their condition.
What if the notice said he's medically unable to do the job because of because of MS? Does that change the outcome?
Yes. And, you know, we've had this argument about there's a policy here that we're willfully blind. And there's nothing in the record to develop that, by the way. There's no reasonable inference to be drawn. You
asked for release and never acted on it.
We didn't receive the release, Your Honor. The record only shows that the release, it was not in the city's file. There's no development by the plaintiff of his own record as to why it didn't make it from one file to the other. Chief Jackson knew he didn't have one and couldn't call Dr. McKinstry. He calls Mr. Deeds and has Mr. Deeds, tells Mr. Deeds that he has a medical disqualification. At this point, Mr. Deeds knows why he was disqualified, but he fails to say anything, Your Honor. That happened before the position was revoked, by the way, which I also think is a key component in this case. There was an opportunity for an interactive process. May I conclude? There was an opportunity for an interactive process at that very moment, and Mr. Deeds should have taken it, and all of our precedent says he should have taken that opportunity. Therefore, I request that you affirm the summary judgment ruling and the Iowa Court of Appeals. Thank you.
Ms. Reasner, thank you as well. Ms. Rollins.
Thank you, Chief Justice, and good morning, everyone. Mr. Deeds' claim against Unity Point presents the following question for this court's consideration. Can a physician who renders a medical opinion about an applicant's fitness for work in response to a prospective employer's request to do so be liable for intentionally aiding and abetting disability discrimination when there is no question that the physician did not willfully provide false or misleading information to the employer? There is no evidence that the physician colluded with the employer to wrongfully deny.
To use the question I asked previous counsel, if this physician was in fact employed by the city, then the acts of the physician might be part of a liability determination. It wouldn't need to be aiding and abetting, but it would provide for a cause of action, I think.
Perhaps as to the underlying discrimination claim against the city. There is no direct discrimination claim against Unity Point.
And if Unity Point was an agent, and I understand, you dispute that, I believe.
We do, Your Honor.
Yeah, sure,
yes.
yeah. But if Unity Point was an agent, that would be a different matter in terms of liability too, right?
In terms of the liability to Unity Point or to the city?
To Unity Point.
Let me make sure I understand the question. Is the question if Dr. McKinstry were acting as an agent of the city, could she be liable for intentionally aiding and abetting the city's ultimate, could she be liable for intentionally aiding and abetting discrimination?
I like that question.
Okay, okay. Respectfully, Your Honor, under the facts in this case, even under the facts in this case, assuming that Dr. McKinstry were an agent of the city, the answer to that question is no. And that is based on several things, but primarily on the plain language of the statute, which requires an intent to cause a wrongful act. The plaintiff relies on...
Let me interrupt you for a second here. The only way that the hospital or the doctor could send the records to the city was because there was a valid release. Is that correct?
It is correct that there was a
But
was a release in the doctor's file.
But without
yes.
that release, you weren't able to even send the initial letter or the initial determination to the city saying that he is medically disqualified. You needed that just to send that information over, under HIPAA, as I understand it.
I'm not sure that that's correct, Your Honor, but
Oh, you could send medical information without a release?
Well, I don't know that the doctor provided medical information. She provided information that indicated he was not medically qualified to perform the essential functions of the firefighter duty.
That's
But,
not medical information?
Your Honor, even if the release was required in order for Dr. McKinstry to provide the information that Mr. Deeds was not medically qualified to perform the essential functions of the firefighter position, that does not create the additional obligation for Dr. McKinstry to provide more information.
That's not the point of my question. The point of my question is that the city had to know there had to be a release in the file in order for them to get the information, and they can't sit back and say, well, we didn't know we can get the information.
Your Honor, I can't speak to what the city did or did not know about what Dr. McKinstry needed in order to provide her qualification assessment to the city.
That might be a fact question, whether they knew or didn't know based upon the information being sent back to them.
It might be a fact question as to what the city was aware Dr. McKinstry had in her file, but that does not change the claim, that does not change that there is no question of fact that precludes summary judgment as to intentional aiding and abetting against the physician. Mr. Borland suggested that Dr. McKinstry acted like a gatekeeper in this case. How? Because she didn't complete paperwork? There was nothing.
Yeah, I think maybe I do somewhat agree with that, because she has the obligation to report back to the city whether he's medically capable of doing this job, and there is a very specific form that's there that she didn't completely fill out, did she? I mean, she could have easily said on that form, this is the reason why he's not medically able to perform the duties of this job, because looking through this other standard, he has MS, and this is the reason for it. Isn't that something she easily could have done and perhaps should have done under these
It's something she could have done. I disagree that
why wouldn't you? Why wouldn't you completely fill out a form to advise the employer? You've been retained by the employer to provide a full medical report. I'll call it a report. We can debate whether it was a full evaluation or not, but that was her obligation to provide that accurate information to the employer, wasn't it?
So two responses to that, Your Honor. First, Dr. McKinstry testified that it's her normal practice not to provide additional information about an employee's underlying medical condition beyond what she believes the employer is asking for, which in this case is a medical determination as to whether Mr. Deeds was qualified to perform the job or not. There's no evidence that practice of hers is evidence of discriminatory intent. Now, as to the existence of an obligation,
it just leads to suspicion when you have the ability to put this information on there and then your practice and procedure is not to put it in there.
I guess I would disagree with that, Your Honor. I think that there's no evidence that Dr. McKinstry would provide information in situations for employees who were not suffering from MS or a similar disability. There's no evidence that this was not her standard practice, regardless of the applicant that she was
Well, that standard
examining.
practice strikes me as potentially quite troublesome, and here's why. Both parties have scenarios that are kind of horror stories, but if you can contract out the medical examination to a third party and then tell a third party, don't tell us any information, just give a green card or a red card, and then we never know what's going on, isn't that a method of avoiding the legal requirements of the ADA and the Iowa Civil Rights Act altogether?
Perhaps, but there's no evidence that happened here, Your Honor. The evidence is that Dr. McKinstry did not provide additional information beyond her conclusion that Mr. Deeds was not medically qualified, and neither Mr. Deeds nor the city asked follow-up questions, even though perhaps they could. So as to a claim that Dr. McKinstry acted with discriminatory intent in assisting the city in making a discriminatory employment determination, there is simply no question of fact that warrants submitting this to a jury. I'd also like to bring, the simplest reason that this court can conclude that summary judgment should enter in favor of Unity Point, regardless of its determination as to the city's liability, is this court's decision in Sahai v. Davies. That is a decision that's been on the books for 20 years. The legislature has never spoken to indicate that it was incorrectly decided, and it is incredibly factually similar to this one, and Unity Point submits that it requires the same result.
You make a Vivian afterwards.
Vivian doesn't change Sahai, Your Honor. It affirms the principle in Sahai that a physician offering an independent medical opinion and in a position to advise the employer cannot, as a matter of law, be liable for disability discrimination under the state statutes. The two cases are factually indistinguishable. Mr. Deeds makes much of the fact that 3 other doctors disagreed with Dr. McKinstry's opinion. And he argues that that fact alone is sufficient evidence from which a reasonable trier of fact could infer that Dr. McKinstry acted with some sort of unfounded fear or speculation about MS rather than in her independent medical judgment. But candidly, a question of fact as to whether a medical opinion is correct or not cannot, as a matter of law or policy, be sufficient to send this question to a jury. Mr. Deeds would have us believe that any time a physician opines that a plaintiff is not, that an applicant is not medically qualified to perform a job, and the plaintiff can present information from different doctors who agree, or different doctors who disagree, then he should be entitled to a jury trial as to whether the doctor intentionally aided or abetted disability discrimination. That cannot be the law. There's a principle in discrimination law generally, I think. It applies to employers, and it should apply equally well to third parties sued under an aiding and abetting claim. And that is that there is room to be wrong. There is room to have an opinion that others disagree with. There is room to make an employment decision based on an honestly held belief, even if it's mistaken. There is room to render a medical opinion, even if others could disagree with it. That is not sufficient to create a question of fact as to discriminatory intent.
Well, let me ask you about intent. That is subjective, I think, but unlike the parts of the Civil Rights Act, like because of language, it doesn't use the word intent. Here we've got intent. Intent to do what exactly? It could be intent to violate the law, kind of a knowing violation, I suppose. It could be intent to engage in stereotypical decision-making. Help me with its intent, and it's subjective, and I'm there 100% that far. Mm-hmm. I mean, you carry me intent to do what?
And I say I'm out of time, if I could respond. Thank you. So I believe the case that plaintiffs cite for a discussion of what an aiding and abetting claim looks like and what the intent requirement under general tort law is helpful here, and that was the Riley v. Anderson case. And that case discusses the absence of, I suppose, a specific intent to commit a wrong in the tort context. So in that case, citing the restatement of torts, the court noted, and this is at page 115 of that opinion, that under general aiding and abetting principles, the tortfeasor doesn't have to consciously desire or want the principal to break the law. They just have to know that what the other person is doing is wrong, and that they gave substantial assistance. I would argue that the additional imposition of a specific intent requirement in the statute does require a finding that Dr. McKinstry was acting, that she knew she was committing an act that violated the Iowa Civil Rights Act. It's the only possible meaning of the addition of the word intent in that statute in light of our general common law on aiding and abetting. Thank you.
Mr. Rollins, thank you as well. Mr. Borland.
Thank you, Your Honor. I have a habit of following up on what I heard most recently, so I'm going to start there. As far as Sahai and the claim that Sahai is factually indistinguishable from this case, the key difference in Sahai that was highlighted in Vivian is the doctor reached out and talked to the employer, so the employer maintained control of the employment decision. That did not happen here. Whereas the doctor in Sahai reached out and said, I'm doing this because of pregnancy and no pregnant women should be working in an assembly plant. The doctor here said medically disqualified, and that is it.
Was there any evidence that the doctor in this case had any role other than to advise the city?
Your Honor, I have a list of things that we would say provide a reasonable jury with a basis to find exactly that. First off is that the MFP-RSI required, section 400.81 of the Iowa Code required that she follow the MFP-RSI medical protocol for applicants. She did not do that because she applied a discriminatory exclusion from the NFPA, which the MFP-RSI says is not allowed. A reasonable jury could also look at the fact that the city of Marion had never adopted the NFPA 1582 standard that the doctor employed. She never conducted a physical examination of Mr. Deeds. She never communicated a basis for the disqualification. She had a signed waiver, but chose not to provide information to the employer. That is the most important fact. Your Honor, she was instructed on the MFP-RSI form that she should provide the information. Had she done that, then we're in Sahai territory. Then she has provided enough information to the employer to actually make the decision. Instead, Dr. McKinstry chose to make the decision for the employer. That's at least what a reasonable jury could find. So when we're talking about intent and acting with the intent to aid or assist, we're looking at intentionally acting rather than acting with a specific intent to discriminate, which the Iowa Supreme Court, to my knowledge, has never said is required for
What about Chief Jackson? What did he think when he got this? Did he think he had authority to quibble or question, or what was his view?
He's quite blunt about that, Your Honor. He's not a doctor. He literally said, the words were he did not have the authority to do anything other than what the doctor said. On, later in his deposition, on what I guess would be a direct or a redirect, Chief Jackson, of course, admitted that it's his decision and his decision is final, but that didn't contradict his earlier testimony that he is bound by. He does not have the authority to overrule the doctor. Unlike Sahai, where, I'm sorry.
Hypothetically, if the city hires somebody for an emergency position, firefighting with a great deal of physical demands, you know, maybe rescuing people from burning buildings, et cetera, but they hire them over medical opinion that that person is not qualified, then a rescue fails, somebody dies, lawsuit against city for negligent hiring. Would that case go to the jury?
Oh, Your Honor, I'm not. I only practice in employment law, so I'm not confident in my answer. I see exactly what you're getting at. If the system works how it's supposed to, how MFP-RSI says it shall, and under our statutes, it is required. It is a mandatory process. And the doctor had provided the information necessary for the employer to make an educated decision rather than just relying on disability stereotypes, then I think they probably have a pretty good defense if they go through the work that they're required to do.
So what would the reasonable accommodation have been in this case had they worked through it? If Mr. Deeds had said, hey, I can do this job, I've got doctors that say I can, MS isn't a reason not to hire me.
There's no accommodation, Your Honor. He didn't need an accommodation. 3 neurologists said he'd go do the job without an accommodation. That's our fact issue. And that's what's inconsistent about the district court's opinion, is that it says there are the words that Judge Bruns used, there are serious disputes of fact as to qualification.
It's a stupid question. If no accommodation is needed, how is he disabled?
He's disabled, if we look at the reasoning in Goodpasture with another MS case, if he were to have flare-ups, then that could satisfy the first element.
In Goodpasture, needing an accommodation, I think it was another backup driver. You saying your client doesn't need one.
Absolutely not, Your Honor. And we've never taken that position that he needed an accommodation. That said, the district court found that there were element of our claim. And nobody has challenged, Your Honor, if I may, nobody has challenged that holding. Nobody has appealed the district court's holding that there are disputed issues of material fact as to disability. Did I answer your question? Yes. Thank you, Your Honor.
Mr. Borland, thank you as well, and again, thank you. The case of Deeds versus City of Marion is now then submitted to the court. And let me just thank the members of the Ray Society for being with us this morning, for coming into court. And we hope you enjoyed the proceedings and found it informative. So we're going to sit in recess for just a few minutes to allow you to leave before calling the next case.